Okay, hi everyone. I just wanted to say very big thank you to Jean for inviting me, and also what a privilege it's been over the last sort of 1.5 days of sessions to hear so many interesting viewpoints and perspectives. And I realize I have the very nice task of being the last presenter, so hopefully I won't bore you too much, and we'll see how it goes. But a lot of what I'm going to be talking about, I think, has already been mentioned. It's just that I wanted to talk a little bit about the overview of things as I see it. So, because we're talking about multinational enterprises in terms of the actual topic of the conference, I thought I would locate that in relation to the accountability of corporate groups. And here I'm mentioning this idea of a missing link of corporate governance, but because I want us to think about corporate governance in a broader sense, and I'll explain what I mean by that. So, thinking about the overview of the paper that I'm looking at, I've heard the word neoliberal only once, and that was yesterday from Charlotte. So I'm going to use it twice today, and so basically, in terms of starting off with the background, I'm going to talk about how globalization and neoliberal globalization has influenced what we understand in terms of multinational enterprises and parents and subsidiary companies, and in terms of global value, supply, poverty, or reliance chains. So at the moment, I'm not sure what it is that we're going to be using, but I thought I'd put all of this in because this is what we talked about yesterday. And in that sense, I wanted to talk about how trying to make corporations more socially responsible, we have had these international CSR instruments. But the problem, and we've all acknowledged this, is this idea that they're all voluntary. But I'm going to talk a little bit more about that. Recently, and when I say recently, it's been probably like for a while now, we have what I call this transnational corporate accountability movement. And I'm going to talk about it in terms of CA. So we've had a number of them over the last day and a half. And I call these post-voluntarist because they're different strategies and strands that are used to try and make corporations more accountable. However, I believe that there are limitations to this, and I think we also talked about this, that there are limitations. And the limitations basically is because of the fact that I think the corporate accountability movement doesn't take into account corporate governance structures. And what I mean by corporate governance structures are what speakers before me have talked about. But therefore, I think that as corporate accountability activists and also academics, et cetera, that we need to be engaging with the reform of corporate governance. But I also want to talk about that reform in terms of education. So, and when I mean education, I'm thinking about business schools as well as law schools. So let's see how far I get in 20 minutes. Right, so in terms of neoliberal globalization, what do we mean by this? I think we can all agree that since sort of like late 1980s, 1990s, we have this movement, if you want, about having to privatize, having to deregulate, and all to be able to make sure that there is capital mobility. So this is really what we're looking at. And in that sense, the beneficiaries, I think, of this neoliberal globalization have been multinational enterprises. And in that sense, then we've also had the global value chains, etc. The problem with then trying to make corporations accountable is that we have these concepts that we've already looked at, separate corporate personality and limited liability. It's really hard to make corporations accountable in that sense. And I think it's really important that we acknowledge that law has actually acted as a facilitator in that sense. Because what law has done is actually created the space for multinational enterprises and various different corporations to actually be able to move around. So in that sense, I see law as having protected the interests of capital. On the other hand, then with this hard law and international economic law structures, for instance, protecting the interests of capital, to try and make corporations more socially accountable, we have had the advent of CSR, so the voluntary or soft law aspects. So let's focus a little bit more on what we mean by CSR. So what the emphasis is on, as opposed to trying to define it, is that we're looking at voluntary, bottom-up self-regulation by private actors. And this would be, as you will all recognize, codes of conduct, statements of intent, and very recently we have these partnership, multi-stakeholder initiatives, etc., etc. My belief is that this implicitly endorses the neoliberal claim that states should play but a limited role in economic affairs. So this idea that the state should not be regulating corporations, because what the law is doing is actually, even though we have various different laws, what it actually does is it enables corporations, so facilitates corporations, rather than the other way around, which is to regulate them. We also talk about CSR as being good for the bottom line, because we talk about this business case for CSR. So corporations should engage in CSR because it's good for shareholders, and we also talk a lot about it's good for shareholders in the long term. So in the UK, for instance, we have section 172 that talks about how we need to have enlightened shareholder value because we're thinking about the long term. Now, because CSR as a voluntary mechanism or as a voluntary movement has been failing, if you want, and because of so many criticisms, what's happened is that we can see a distinction or an emergence going around, which is known as a corporate accountability movement. So instead of focusing on responsibility, which I'm going to explain why we focus on accountability instead of responsibility, is because of this. Oh, sorry about this. So corporate accountability can be defined as the ability of those affected by a corporation to regulate the activities of that corporation, and the corporate accountability movement defined as those who work toward this outcome. So unlike contemporary CSR and the movement behind it, which is very much, as I say, within the neoliberal framework, about not putting the state in terms of regulation of companies, what the corporate accountability movement tries to do is to regulate the activities and using, for instance, power of the state. So what we're talking about when we talk about accountability are two things. One is answerability, which is this idea that you have to provide an account for your actions that you have undertaken, but also the enforceability part, which is very important here, because it's about this idea that there will be punishment or sanctions for poor performance. And these sanctions, most of the time, we see them as being state-backed sanctions. Right, so in the paper I focus a little bit more on the corporate accountability movement, and I here want to just quickly go through some of these strands and strategies, and they've already been mentioned by a number of you. So we have these private law mechanisms. So for instance, and you will recognize some of those. So for instance, this indirect force of law to codes of conduct. Andreas has written quite a bit about the private law mechanisms in terms of CSR. We also have the contractual control element in supply or value chains, and I'll talk a bit more about that in a minute, but also we've heard from it. We've also got tort law, which you've heard from already. And here I've put under tort law still, although it can be seen as an international law instrument, which is the Aliens Tort Claims Act in the US, which is seen as being foreign direct liability. So again, trying to make corporations and parent companies, more liable. This has closed, Kiobel has closed the door a little bit to this, but at the moment we have the case of Jesner, which is in front of the US Supreme Court. So we need to find out whether this is going to work or not. Other strategies are the UNGPs, which we've heard about. We also have these CSR legislations in developing countries, which is, so Indonesia became the first country in the world to try and regulate CSR, although it hasn't properly implemented that legislation. Then, I'm going to drink some water. Then in 2009 and 2013-14, India also legislated a CSR legislation. But I call this legislating corporate philanthropy, because what they do is simply to ask corporations to give a percentage of their profits towards community development initiatives. And then, again, the reporting sort of legislation, so the UK Modern Slavery Act, and I think which goes a little bit further, and which we've mentioned already, the Friend Duty of Vigilance law. So because we were focusing a little bit more in terms of supply or value chains, I thought I'd just briefly talk about the limitations here. And we've just heard from presenters talking about the certification sort of mechanisms that there are. So I just want to talk about this particular element of codes of conduct that would be in the terms and conditions in contracts with the suppliers. And usually these would be in developing countries. Again, not sure at the term developing countries, but for our purposes today, we'll understand what that means. And this has been labeled as being other regulation, in the sense that business enterprises here are attempting to regulate other businesses. Now, one of the ways that they do this, and we have heard about this, is in terms of the compliance audits that are performed in terms of all these various different private certifications, etc., etc. The problem is that this isn't working. And the Sheffield Political Economy Research Institute published a report last year, again, looking at Andreas. And what it said is that the audit regime is working for corporations, but failing workers and the planet. It reinforces existing business models and preserves the global production status quo. So basically, one of the examples in terms of looking at this shows that this isn't working. Right, so when it talks about this idea that it reinforces existing business models, what do we mean by this? And this is where I think we now need to think about the corporate governance element. Right, and this is what I'm saying, that corporate accountability, activists, academics, etc., are not looking at this in that sense. Right, so we all understand what corporate governance means, but really what we mean by this is the processes and various different things that we take into account when we're trying to control corporations. Now, the mainstream model, usually the Anglo-American model, is all about shareholder value maximization. But also, when we're thinking about accountability, so whereas the corporate accountability movement is trying to make corporations accountable to stakeholders or even the public, here, the accountability is to shareholders. So there is a disconnect in that sense. And the debate has acknowledged this, also moved on, if you want, a little bit from this, because there have been a number of reforms that have been suggested. So we've suggested, for instance, that we need to look at the corporate rights structure in that sense. So should we give shareholders voting rights or not, especially in terms of thinking about whether they actually are the owners of the corporation or not. And my view is that they're not, but that's another, another talk. And also in terms of the composition of boards, which is more in terms of the stakeholder theory, thinking about, okay, having employees and other stakeholders on boards of directors. Another crucial element of this would be to then, and this is Jean's pet project, I think, which is to think about the nature of the corporation. So is it a private property, or is it a public institution, or a quasi-public institution? And so if we engage with these sorts of ideas and reforms, then again, we're trying to look at, okay, well, how are we going to change things? I think, at the end of the day, what corporate accountability wants to do is to socialize this asocial corporation. So with all these various different reforms that we might be thinking about and changing what it means in terms of what the corporation is, etc., etc., one very important part of that, I think, is to think about education, because I think when we usually think about corporations, a number of us just are simply talking about, oh, well, this is a legal entity, and we talked about the various different elements of corporate fund, which is what Susan talked about, etc., etc. But I think it's important to remember that corporations are made up of people. And when we're talking about people and the people who are in charge, then we need to be thinking about those people who are going to be directors, who are going to be managers, who are going to be in control of the corporation. So we need to think about how we're going to do this. And I think here, this is where it's absolutely crucial that the role of business schools and law schools are taken into account. So if we think about what business and law schools talk about in terms of corporate governance, it's whether it's the management theory or company law, we tend to look at this idea that the main aim of company law is about making sure that directors are going to work for the company, but most of the time we mean shareholders and shareholder value maximization. So, and this is based upon the agency theory, which is this idea that managers are principals of whether it's a company, but most of the time seeing it as being agents of shareholders. And I've been reading a lot of management theory, as well as various different business school literature, etc. And I came across a professor of London Business School who unfortunately passed away, and this was in 2005, and this was his last sort of article. And he says the agency theory underlies the entire intellectual edifice in support of shareholder value maximization. So what we have is this, that it's very mainstream that we're talking about agency theory. Or if we want to talk about CSR and business ethics, then usually they're going to be standalone courses and usually optional as well. So students don't really need to be thinking about this. Now, when we come to human rights law, on the other hand, then what we're looking at usually is in terms of trying to benchmark corporate conduct against universally recognized human rights principles, which are embodied in key treaties. And the focus is on remedies. So, as a student, if you decide to learn company law, then you hear about those types of things. If you decide that you might want to look at human rights law, then this is what you're going to be doing. So I teach business and human rights, and we've had this discussion before, where I think that a number of students that come to business and human rights tend to focus on this part of the of what it is that they want to do, as opposed to thinking about, okay, well, if it's ingrained that this is the agency theory and this is about shareholder value, then it's going to be really hard to try and see how these two are going to work together. So we need to have that dialogue. And I think we need to have that dialogue because we have academic freedom. So as academics, we should take risks. We should be thinking, okay, let's try and change the way that we actually are going to be teaching these various different subjects. And I read a book by Khurana, who's in the States, and he was talking about how in the 1920s, when we first had business schools, they actually were talking about professionals and professional managers. And it was all about embedding professionalism with the broader interests of society. And this has been lost somewhat from the 1980s onwards because of neoliberalism. So I think what is important that we try and do is to have these courses that explain how to implement social accountability as part of a core or compulsory part of whatever degree it is that we're doing. So if we have these various different laws, for instance, in terms of reporting, what is it that a particular student has to do so that when they go off in the marketplace and do eventually maybe become a director or whatever it is, they actually do realize that, okay, this is maybe how I should be thinking about doing things. Right, so conclusion, and nearly going to stop. I think what I'm saying here is not that the corporate accountability movement is not worthwhile. It absolutely is worthwhile because it has shown that there are different ways of regulating business conduct and to make sure that there is socially responsible conduct. But I think if it wants to be a genuine countervailing force, so really push for social accountability, that it needs to engage with corporate governance reform. And this is institutionally, so in terms of talking about it, but also culturally, because managers are the ones that are going to try and make a change. And this requires deep cultural change, so it's not going to happen overnight. So we need to think in terms of how we are going to be able to do this. And I think It's important to do this because our future depends on it. Thank you very much for your attention.